Welcome to the ninth lecture in the AMBI Law and Bioethics series. Like last week, the current topic, pediatrics and the law, is an extraordinarily expansive topic, and we could not cover all of it in the course, let alone a lecture. So the three areas I want to talk about today are the right to refuse medical care, and I want to start by talking about the adult right to refuse medical care, which we've touched on before but really haven't explored, and then show how the rules are different for children versus adults. Then I'm going to discuss various definitions of adulthood and how the law applies to children differently from adults in various circumstances. And finally, we'll review the ethical and legal issues at stake when the wishes of parents and their minor children conflict. So a reminder that this is not law school, and you should not memorize the cases. You should simply come up with an understanding of the concepts. And it's important to remember that the right to refuse medical care as a competent adult, something that we take for granted, was not the norm in American healthcare in the 19th century. And it was actually a couple of cases that changed this. And the first well-known case was that of Union Pacific Railroad Company versus Botsford. And what happened in this case was a woman was injured on a railroad trip when the berth above her dislodged and fell and hit her on the head, and she was severely injured. And she sued the railroad company. And the railroad company insisted that the doctor had a right to surgically examine her brain in order to obtain evidence for trial. Now, obviously, the railroad company wasn't particularly interested in the evidence. What they were interested in was creating an additional obstacle for her to win her lawsuit, because most people wouldn't agree to invasive surgery for litigation purposes. And she refused, and she sued and claimed that she did not have to disclose the interior contents of her skull. And the court decided this was too invasive a demand, and there are certain limits, and bodily integrity has to be protected in certain ways. And they refused to grant the railroad's request. So the case was heard by the U.S. Supreme Court, but it's important to emphasize that it was not a constitutional law case. The railroad accident had actually occurred in the state of Indiana, but because the railroad company was a national company, the lawsuit occurred in federal court. And this was simply a question as to what the rules are governing procedure in federal courts. And in federal courts at the time, the U.S. Supreme Court looked to the common law of the individual state where the occurrence had occurred, what the judge-made law and precedent were in that state. And that was what the Supreme Court debated. And then the famous quote, Justice Horace Gray, otherwise not a terribly famous Supreme Court justice, whose great other claim to fame is he was the first Supreme Court justice to hire a law clerk and actually paid for him out of pocket, was that no right is held more sacred or is more carefully guarded by the common law than the right of every individual to the possession and control of his own person, free from all restraint or interference of others, unless by clear and unquestionable authority of law. Now, that may seem obvious to us today, but at least two justices, Justices Brown and Brewer, dissented from this opinion. They felt that whatever interest the woman in this case had in not having unwanted exploratory surgery, the interest in establishing truth was more important in civil litigation. And while they wouldn't have ordered such an investigation in a criminal case, since she was choosing to pursue the lawsuit, they felt that she had to expose her brain, if required by the railroad company, to further the overarching goal of truth. 13 years later, in the case of Schlondorf versus Society of New York Hospital, a New York State case, Mrs. Schlondorf went to a New York City hospital with a stomach tumor, and the doctors wanted to operate on it. But they told her all they were going to do was to explore it under anesthesia to see the extent of the tumor, because it was a risky operation and she did not want to remove because she was afraid of the risks. Yet once she was under anesthesia, they did the surgery anyway. She sued on the grounds that only she had the right to determine what was done to her body, and in a novel case, she won, establishing for the first time the right to bodily autonomy and integrity in New York State. These are early examples of the shift from paternity to autonomy in Western medical culture, and they further the argument that this transformation occurred as a result of judicial intervention rather than as a result of the grassroots movement for patient rights in the 1960s. It's worth noting there are two conceptual theories in the law as relates to this shift. One is that both patient rights advocates and doctors empowered by their experiences either fighting in Vietnam or protesting Vietnam, and working in the public sector, places like the Indian Health Service, and in concordance with the civil rights movement and the women's rights movement, started to empower patients. And that is what led to the shift from maternalism to autonomy. But there's another argument that says that courts were actually the leading voice in this. You could think back to cases like Canterbury versus Spence, where the very liberal court led by Spotswood Robinson said that even without an expert, Jerry Canterbury had a right to have his case heard by a jury regarding the bed rouse, or Helling versus Carey, in which not having an expert in the local community who said this was the standard of care didn't mean the patient couldn't claim that doctors had all fallen behind as a profession, that these shifts were imposed by the courts, and that the model, I like to show the slide of Robert Young in Fathers Knows Best to Frank Sinatra, I'll do it my way, is really less a patient-driven phenomenon and more a phenomenon of the legal system. And then if you want to take that one step further, why? Because as both of these cases demonstrate, the interest was in acquiring payouts for lawyers who were heavily connected to the bar and the bench. I'd like to emphasize that the move toward autonomy was a very slow one, because the most famous case in the history of the right to refuse medical care in the United States is actually one where such refusal was denied. And it was the case of the application of the president and directors of Georgetown College. And in this case, Mrs. Jones was a 25-year-old woman who was a devout Jehovah's Witness who did not believe in the morality of blood transfusions. And she had a young child and was married, and she had an ulcer that bled so that she lost 2/3 of the blood in her body by the time she arrived at Georgetown Hospital, according to hospital records and court records. And the hospital applied for a court order mandating that she receive blood, and the case actually went to Skelly Wright. And you may remember Skelly Wright as a great liberal judge from past cases. He, for example, was one of the judges in the Canterbury versus Spence case. He was also well known as a Southern judge who strongly favored civil rights. But in this case, he took a position that many now view as very conservative, and found that Mrs. Jones did not have a right to refuse the blood transfusion. He interviewed her husband. He actually interviewed her at bedside, and then court-ordered blood. And his famous quote is, "If self-homicide is a crime, there is no exception to the law's command for those who believe the crime to be divinely ordained." So he did not make an exception for religion in the generalized rules of the state. One of the most striking features of this ruling is the rationale that he used. Among other rationales, he said, the child cases point up to another consideration. The patient, a 25-year-old, was the mother of a 7-month-old child. The state will not allow a parent to abandon a child, and so it should not allow this most ultimate of voluntary abandonments. The patient has a responsibility to the community to care for her infant. Thus, the people had an interest in preserving the life of his mother. I mention that because this is a rationale that's been used in a number of other cases going forward to keep women alive through forced medical care because they need to take care of their children in the future. To my knowledge, there are no cases involving men, so it's highly gendered. But it also suggests that maybe had Mrs. Jones not had a child or a young child, Wright might have come to a different conclusion. In New York State, the law establishing the right of religious dissenters to refuse medical care when they had capacity wasn't formally established until Fossmeyer versus Niccolo. And in this case, Mrs. Niccolo, who was an emergency room nurse on Long Island and a long-standing devout Jehovah's Witness with collateral evidence from her husband that this was her belief, before she gave birth to a child during her pregnancy, said that she would rather die than receive a blood transfusion if she needed one during a complex pregnancy. Her child was delivered by C-section, and the baby was healthy. After the delivery, when the child's life was no longer in danger, she then needed a blood transfusion, according to the doctors, and they gave her one, even knowing that in writing she had made clear she did not want one. She survived. She likely would have died had she not survived, and she sued. And she won a very large payout, which means that in the future, doctors are going to be very reluctant to give Jehovah's Witnesses blood transfusions against their will in New York State. But it does raise the question how much money one deserves in such a case. We established earlier in the course that malpractice requires damage, and the payout should be based on the damage done. But the damage here done is not tangible in any way. The damage here is entirely spiritual or moral. How do you place an economic number on the consequences for Miss Niccolo, such as damnation in the afterlife or moral distress? And how do you balance that against having her life saved, which also seems to be a priceless amount? So, in some sense, the court places an arbitrary number on something that is theoretically impossible to measure. A number of states still require medical care to save fetal life, and a number of states actually will court order C-sections for patients against their will to preserve fetal life. New York State, to my knowledge, has not done this in recent memory, but the law in the area remains very unsettled. Now I want to shift toward children specifically. And before we actually get to medical cases, we want to ask ourselves, are there constitutional limits? Does the liberty in the Constitution place limits on how far the state can interfere in the parental authority over children? And there are two non-medical cases that precede the famous medical cases in this area. One of them is the case of Meyer versus Nebraska, and the facts of the case actually arose during World War I, even though the case didn't reach the Supreme Court until 1923. And in this case, the state of Nebraska during World War I, motivated by strong anti-German sentiment, had banned parents from teaching their adolescent children German. And a parent who wanted to teach her child German, I believe they were sending it to a private German school outside of regular school hours, sued and said this interfered with the rights of her as a parent. And the Supreme Court agreed. The right to teach your child a foreign language was a fundamental right under the Constitution. 2 years later, in Pierce v. Society of Sisters, Oregon, driven by the machinations of the Ku Klux Klan and some far-right organizations at a time when there was a very strong anti-Catholic sentiment in Oregon, made compulsory public school attendance mandatory. Their goal, of course, was to keep Catholic children from going to Catholic schools. And the Society of Sisters, which ran such a school, sued the state. And again, the Supreme Court ruled that sending your kids to private school, as long as you gave them a meaningful education that was roughly analogous to the public school education, was a liberty interest under the Constitution. Many of the early cases involving children's rights relate to Jehovah's Witnesses. And Chief Justice Stone once said famously, "I think Jehovah's Witnesses ought to have an endowment in view of the aid which they give in solving the legal problems of civil liberties, because there were so many lawsuits." And if you're not familiar with Jehovah's Witnesses, other than turning down blood transfusions, they don't engage in military service. They're conscientious objectors, which during World War II led to a lot of negative sentiment toward Jehovah's Witnesses. They also defer substantially to the legal system. So while they will sue for rights, if the court rules against them, they will follow the court order for the most part rather than violating it, which makes them different from a number of other religious dissenting groups. I assigned for this week the seminal case of Prince versus Massachusetts. It's important to note the date the case first arose in Prince versus Massachusetts. It occurs a few weeks after the Japanese bombing of Pearl Harbor. So anti-Jehovah's Witness sentiment at a time when they were conscientious objectors was particularly strong in the United States. And in this case, a woman named Sarah Prince took her ward, who happened to also be her niece, Betty Simmons, out to sell pamphlets for 5 cents each. There's some debate in the case whether the pamphlets were sold at cost or whether they were trying to generate revenue for the Jehovah's Witness community. But this was not a large-scale, thriving economic business. This was an occasional event where Mrs. Prince went out and sold pamphlets. I will mention, by the way, her niece, Betty Simmons, is apparently still alive and living in Massachusetts. If anybody ever wanted to do a research project and interview her, I think it'd be a fascinating project. She lives in, I believe it's called Brockton, and is around 90. With that in mind, a local watchman challenged Mrs. Prince, and eventually she was fined for violating the state child labor law, and the case worked its way all the way to the U.S. Supreme Court. I only gave you 2 of the 3 opinions in the case for reading to spare you the extra legal reading, but I will mention all 3 of the court's opinions today. So the majority opinion was written by Wiley Rutledge, who himself was known as a very strong civil libertarian. And he made two determinations in the case. First, for him, this was not a case about religious freedom. This was largely a case about child labor. And he wrote, parents may be free to become martyrs themselves, but it does not follow they are free, in identical circumstances, to make martyrs of their children before they have reached the age of full and legal discretion, where they can make choices for themselves. And that is one of the most famous quotes in all of pediatric law. The principle being that the child should be kept alive until the child reaches the age of majority, where then they can weigh on decisions. Of course, if you get a blood transfusion as a minor and that leads to damnation in the afterlife, it's very hard to undo that once you become an adult because the damage is already done. It's also important to emphasize that this wasn't fundamentally a religious freedom case for Rutledge. It was a case of uniform application of the child labor laws. He didn't see this as fundamentally different from a young child being asked to work in a factory. He viewed the religious element as a guise for fundraising for the Jehovah's Witness community. The dissenting justice in the case, Justice Murphy, agrees in principle with what Wiley Rutledge has to say, that people have a right to make martyrs of themselves, but not of their children, and favors child labor laws just the same way that Justice Rutledge does. He just doesn't view the facts in the case as justifying such an intervention here, because he doesn't view what Betty Simmons is doing as child labor. He views this as fundamentally a religious exercise that is only incidentally economic. The record makes clear the basic fact that Betty Simmons, the 9-year-old child in question, was engaged in a genuine religious rather than commercial activity. So the debate between Rutledge and Murphy is whether or not this is economics or religion. But there's a concurring opinion, which you should pay close attention to, by Justice Robert Jackson, who later became the Nuremberg prosecutor. And Justice Jackson said it doesn't matter whether it's religion or it's economics, and it doesn't matter whether it's adults or children. He wrote, "My own view may be shortly put. I think the limits begin to operate whenever the activities begin to affect or collide with liberties of others or of the public. Religious activities which concern only members of the faith ought to be free, as nearly absolutely free as anything can be. But anything beyond these, many religious denominations or sects engage in collateral and secular activities intended to obtain means from unbelievers to sustain the worshippers and their leaders. All such money-raising activities in a public scale are, I think, Caesar's affairs, may be regulated by the state." So Jackson has offered a alternative view to the current view in the United States. Currently, we make a distinction between not just in medical care, but in many cases, whether the activity is engaged in by adults or engaged in by children. Jackson says that's not a meaningful dividing line. Rather, the meaningful dividing line is whether it only affects an insular community or affects the rest of us. So, as I mentioned earlier, if the Amish want to teach their children carpentry rather than mathematics and English, we let them do that because we know they don't end up on the public dole when they grow up. On the other hand, if you decide you're going to opt out of standard curriculum and only teach your children macrame and scrimshaw, we don't let you do that because the odds are they will end up unemployed. It's clear under Prince, which is still the precedent in the law of the United States, that courts and the government have some right to impose medical care on children and adolescents over their parental objections, even if those objections are religious. But what the boundaries of that remain very fluid. So I asked you to read the Sampson case from Ulster County in New York State, in the 1970s. The fact of the case actually, I believe, rose in the 1960s. And this is a case where the child had a debilitating growth. You should ask yourself, was this a cosmetic intervention or a medical intervention? And does the distinction matter? Does it matter whether the child is suffering because he faces some possibility of blindness or deafness going forward versus that he's suffering because he's psychologically damaged? And in this case, the growth was so unsightly, as I recall, that Kevin Sampson was sent home from school in 3rd grade by the teachers because he was scaring the other students and had to be homeschooled. Obviously, that would not happen today. It's also worth noting these cases occur much less often today because Jehovah's Witnesses, officially at least, allow the acceptance of partial products of blood and defer to individual conscience. And a number of Jehovah's Witness cases I've been in, while people raise their objections, they also defer to court authority. We might even ask the question whether they're hoping the courts impose a blood transfusion upon them. Well, another question that arises is how much risk a pediatric or adolescent patient should have to entail in order to obtain treatment when they don't want that treatment. So a companion case is that of Cassandra C. This was a Connecticut case where a 17-year-old girl with Hodgkin's lymphoma refused chemotherapy. The estimates were that she had very little, if any, chance of surviving without chemotherapy, but her life expectancy was unclear, but had an 80 to 85% chance of survival with chemotherapy. But she had been through a round of chemotherapy and hated the side effects and said with confidence she would rather die than continue with the care. And her mother supported her in this decision. Had she been 18 years old, it is very clear under state law, as an adult, she would have had the right to refuse chemotherapy. Why does the fact that she was 17, even with parental support for her decision, and even though she was making an informed decision about risks, benefits, and suffering, mean that she didn't have the right to make that decision? It's worth thinking about. The courts ruled against her for what it's worth. And my understanding is she got the treatment and is still alive today. An ongoing controversy in New York State revolves the ultra-Orthodox religious practice of Mesitzah B'Peh, which I should emphasize only some ultra-Orthodox Jews engage in. It is the oral suction of blood during the Brit Milah, the circumcision of the newborn infant. Unfortunately, it also can spread the herpes virus, and a small and rare but significant number of children have been hospitalized and even died as a result. And the question is, how much risk should a community be able to impose upon infants in order to maintain a many thousand-year-old cultural practice? Similar issues have arisen around the practice of female genital cutting. I am not going to call it either female circumcision or female genital mutilation because I'm trying to keep this as neutral as possible from a legal standpoint, but those terms are also used. It is a practice that has been banned in many states. You can look at the map on the left. The green states have banned the practice. The red states have not banned the practice. It was actually banned federally under the Female Genital Mutilation Act of 1996, but that act was declared unconstitutional by Judge Bernard Friedman. We talked about the Commerce Clause. He felt that this was beyond the purview of the federal government, that female genital cutting did not in any way impact interstate commerce. Of note, a few years ago, under the Trump administration, the federal government repassed similar legislation that explained in detail how this practice supposedly did impact interstate commerce. The content of the law hasn't changed, only their preamble explaining its impact has changed. We'll see if that has an impact on what the courts decide. And then the American Association of Pediatricians issued very controversial guidance at one point, suggesting that a ceremonial nick in the female genital organs shortly after birth was acceptable if it didn't impact health or function, and there was a widespread backlash against that. But it's worth comparing that ceremonial nick to the practice of male circumcision. Iceland attempted to ban male circumcision or male genital cutting for non-medical purposes in 2018, but backed down. This issue has been on the agenda in Sweden and in Germany over the last decade. You should ask yourself, would a U.S. ban be constitutional if a state, for example, decided to ban male circumcision and an Orthodox Jewish parent sued and said there's a liberty interest in circumcising my child? Would this be more analogous to Pierce versus Sisters and Meyer versus Nebraska, teaching your children German or sending them to private school? Or would it be more like Prince versus Massachusetts, where the court might intervene and say that people as adults certainly have a right to be circumcised, but the job of the courts or the right of the state is to keep them intact, which is the language of opponents of circumcision, until adulthood when they can make an informed decision? I don't have an easy answer to that, but I think it would pose a fascinating legal case under the 14th Amendment. When one becomes an adult has been a controversial issue for a number of years. Most states still use the age of 18 for most purposes, though, as we've learned in this course, Alabama uses the age of 19, as do a handful of others. And that applies to making decisions in contract and buying property. It doesn't necessarily involve personal decisions. Some states, for example, have a lower age of consent for marriage. But in the medical sense, there are two different standards that have been used. There's the standard that you're a minor until you're emancipated, which is I like to describe as a per se line. It's sort of like you must be taller than this line to ride this ride at the amusement park. And I will add that I never was. So college students are familiar with this because you must be 21 to buy a drink. It doesn't matter if you're 20 and can prove that you hold your liquor. It's a per se rule, like a stop sign. So emancipated minors, who basically are individuals under 18 or 19, depending on the state, who meet certain statutory guidelines. Like in many states, they're married, they've had a child, they've served in the military. And if they haven't met one of those criteria, they're not emancipated. They can also apply to a court to be emancipated, showing they're fully independent. They don't get to make any medical decisions at all. Then there are a number of other states which use a much more sliding scale approach and say that if a minor is mature enough, they understand their condition, sometimes also combined with being over a certain age, they are allowed to make medical decisions for themselves. And this is more like a discretionary rule, like you must be sober in order to buy a drink, and how drunk you are becomes a matter of discretion for the bartender. And then a number of states, both mature minor and emancipated minor states, have carve-out exemptions. So, for example, in New York State, there are specific carve-outs that allow adolescents to make decisions relating reproductive health, sexually transmitted diseases, substance use and drug and alcohol treatment, psychiatric treatment that are considered sensitive in one way or another, or things that adolescents might be reluctant to get care for if their parents became aware, that defy the general rule. You may have seen the case of Laura Parker Russo. She was a teacher on Long Island who earlier this year offered an injection to one of her son's friends, giving him a COVID vaccine, even though she was not a licensed physician, and now she faces a court case. I want to emphasize that in New York State, the problem here is that she was practicing medicine without a license. It actually turns out, had she been a physician, even without parental consent, she would have been able to vaccinate this young man, because New York State allows anybody in custody of a child with their parents' permission, meaning the custody occurs by permission, such as a babysitter or a relative, even if they're not a guardian or parent, to authorize vaccination. It's one of the rare exceptions to New York State law. I wonder if that will change, though, as a result of COVID. A well-known case that addresses the issue of emancipated versus mature minors was that of a young man named Starchild Abraham Wolfe Charitz. Yes, you heard that right. Starchild Abraham Wolfe Charitz, who developed Hodgkin's lymphoma, and at the age of 16, I believe, wanted to discontinue care with the support of his parents to pursue non-traditional treatment. And Virginia at the time was an emancipated minor state, meaning that if you weren't 18, you couldn't make your own medical decisions. And his parents were charged with neglect, and he was forced back into care. He eventually did get care and survived the treatment, and my understanding is after he turned 18, he chose to pursue conventional treatment and now remains alive and healthy. The point being that maybe Justice Rutledge's view of keeping someone alive until they reach the age of majority has some merit to it. But the state responded with what is known as Abraham's Law, that shifts Virginia from an emancipated minor state to a mature minor state, that individuals over 14, with the consent of their parents, have some authority to turn down unwanted care, particularly in cases like cancer. I mention that because it requires collaboration between parents and child. That's Governor Tom Kean, who supported the law. I mention that because Abraham's Law does not allow children to turn down care their parents want them to have, which differs from the rules in many other mature minor states. I also want to mention the three kinds of conflicts of the values that occur in cases relating to pediatrics in the law. The first is those in which parents can agree on how their child should be treated by the medical system. And there are two well-known examples of this. First is when parents can agree on whether or not circumcision should occur. So on the left, you see a picture of Heather Hieronymus. She was a woman who initially agreed and then later refused after a breakup to have her son circumcised, and she actually went on a lam. Most states require one-parent consent for circumcision. In contrast, the Fraunhofen Protocol in Holland, which allows for euthanasia for infants who have no life expectancy, basically, if you're going to live for 6 weeks or 8 weeks and suffer, they allow you to have an injection with potassium to end your life more briefly, requires two-parent consent. I actually, as you may know, have written an article which challenges this, which argues that if your rationale is the best interest of the child in suffering, maybe the parent who wants the child not to suffer should trump the parent who wants to preserve life when life will end anyway. But that's a complex question because both parents have to live with the result, and I don't think there's an easy answer. The second kind of case arises when there's a conflict of interest between the parent and the child. Um, I will make available, if I haven't yet, the Andrew Bednar case, an article I wrote about it. Andrew Bednar was a man who abused his child, and as a result of that abuse, the child ended up on life support, and he opposed removing the child from life support, allegedly on religious grounds, but at the same time, he had a stake in that because if the child were removed from life support, he would have faced a murder charge. Eventually, the courts mandated the child be removed. That was in the child's best interest, and Bednar did face a murder charge. The most complex area of law, and one that we can discuss either in a Zoom session or on the forums, is what happens when an adolescent who, if they were an adult, would be deemed to have capacity or be competent to make medical decisions, has an illness that is longstanding and debilitating and wants to turn down care their parents want them to have. So, for example, a 16 or 17-year-old with cystic fibrosis who doesn't want a lung transplant, and parents who do want them to have it. And at the opposite turn, what happens when you have parents who have a religious belief that refuses care of certain sorts, and the child wants to get that care, particularly in a non-life-saving intervention, something, for example, that is cosmetic. And the laws vary greatly from state to state, but this is an area of considerable fluidity, and I will add a great topic for a paper in this course or beyond. That is the end of the lecture. I hope this has been interesting, and I imagine for many of you it has convinced you that you should hire a lawyer before you have children.